So in a Los Angeles County probate court confirmation sale, how long after the court hearing to confirm the sale is it before you actually close escrow? Well, that's a complicated question. I mean, on one hand, it's pretty simple, the rule. On the other hand, in practice, it's not quite that simple. Let's take a look at it. By law, you're supposed to be closing 10 days after receipt of certified copy of the court order. So after the date of the hearing, and the court says you win the property, there's a couple things that happen. One is you sign an open bid in court form, and that gets filed. So you have your name and how much you bid, you're the winning bidder, and that becomes your contract. The second thing that happens is the judge's clerk creates what's called a minute order. And it's basically like a memo that says the judge approved the sale of this address, this price, these terms, these agents, these commissions on this date. That's called a minute order. But there's another document that's needed in order to close escrow. It's called the court order. And that court order has to be signed by the judge. Now, in some counties, like San Bernardino, the clerk prepares it on the spot, hands the judge signs it, you walk out the door with it. But in LA County and in many other counties, that's not how it works at all. You have to submit the form, get the judge to sign it, and then get it back. So let's break down the process. Step one, submit the order. So, I've been in cases where we won the court order on Monday, but the attorney for the listing agent for the family, my buyer might not have been in a hurry, and the attorney didn't submit the order for a week or longer because they didn't know who the buyer was the day of the court. So they have to either handwrite and submit the order at that time with the name of the new buyer and the dollar amount, or go back to their office and prepare a new document and submit it to the court. Number two, the order has to be correct. And what happens is over half the time, there's a typo or administrative error of some sort, and the judge's assistant sends the document back to the attorney to be redone. And then the attorney has to redo the form and then resubmit it, and the judge has to review it. And I've seen that go on. If each one's a week, if you make two mistakes, right? 1 week to submit, you get it back a couple days later, another week to submit it again. It could be 3 or 4 weeks before the judge actually signs it. That's when the judge is on vacation or isn't too far behind, but generally it's about 2-3 weeks before they sign it. Then you need to have I have a typo there. You have to have a delivery of the document. What does that mean? So you have the document, but you can't just go online and print a copy out. The title companies, for some reason I don't understand, rather have a certified stamp copy that I think is easily forgeable, rather than go online and verify the legitimacy of a document. And they attach that when they record the grant deed. So how do you get that? Well, you could go to the court in LA County at the Moss Courthouse on the first floor in the research room, and you fill out a form, you get the document. It costs like $35 or something, but they stamp it and give you a copy of the certified document. But most people know that's how they do it. And most people don't want to go back to the courthouse. And to be honest, most don't have any idea how to get it. So the listing agent will say, well, title's going to get it. Title will say escrow will get it. Escrow will say, somebody else is going to get it. It goes back and around for a while until somebody has the responsibility to actually get the document. Now, when my customer wants it, I get it right away. I can use either go in person, or there's a service I use that will go pick it up and deliver it wherever we have to have it delivered. Then it's 10 more days. So I've seen cases where the judge signed it and the escrow and the title and listing agent sat around pointing fingers to each other. And if I didn't expedite anybody, it sat for a week or longer before somebody would say, well, why are we closing? Well, we need this document. Where do we get it? And they figure that out. And there's 10 more days. So when a buyer asks me, how long does it take to close once I went the overbid? The answer is you should be ready to close in as soon as 10 days from that date. But in reality, it's probably going to be about 30 days. In practice, that's about how long it takes. So I hope that helps. If not, reach out to me. I'm Bill Gross, the LA probate expert, and I'm always here to help you. My name and phone number and such are down below. And make today your best.